Hello, my name is Dr. K.P. Asha Mukundan. I am a faculty with Tata Institute of Social Sciences, School of Social Work, Center for Criminology and Justice. Today I am going to talk about the module on the principles of the juvenile justice system. This is a module situated within the larger context of the juvenile justice system. The objectives of this course is to understand the principles of the juvenile justice system, to understand the meanings and principles, and then to understand the challenges for effective implementation of the principles. The word juvenile is synonymous to the word child, who is defined as a person not completed 18 years of age. This is a universally accepted definition of a child, which comes from the UN Convention on the Rights of the Child. The word justice means being fair not only within the legal context, but also within the social reality. For example, the issue of children who are illegal immigrants. These children are categorized as children in conflict with law. This can be debated within a legal as well as a social perspective. While socially these children are victims of circumstances, legally it would not be wrong to categorize them as conflict with law. Justice here would be to understand the issue within the social reality and not deem children in conflict with law merely because their parents migrated into another country and brought them along. This module looks into the principles of the juvenile justice system. Principles of the juvenile justice system guide and provide direction to perspectives to an issue and also play an important role, especially at times of conflicts of dilemma that arise when there is a need to take stands on issues faced in the light of working or associating with the system. The principles of the JJ system provide direction of being fair to many questions on debates like should children hailing from Bangladesh get booked as children as CCLs in India? Should young minor couples falling in love and experimenting with sex be viewed as rape? Should soliciting by minors are booked as crime? What should be the upper limit of the child of a juvenile? What should be the age for consensual sex? Principles help mold and shape the experiences and literature, which in turn determine the approach or manner in which the issue would be understood. The approaches towards working with juvenile justice are centered around 1. The due process model, which protects the substantive and procedural rights of the juveniles involved in the legal process. 2. The parens patriae or welfare model, which aims at providing social and legal justice to all the children. And 3rd, participatory model, which emphasizes a constructive participation of the community in the mainstreaming of the erring juveniles and the minimization of the legal interventions in their lives. Here I would like to start talking about the principles under the juvenile justice system, especially in context with the Juvenile Justice Care and Protection of Children Act 2015. The JJ Act has dedicated one complete chapter to the principles, thus emphasizing the importance of reading the Act in the light of the principles while implementing the same. We are going to talk about the first principle, which is the principle of presumption of innocence. Any child shall be presumed to be an innocent of any malified or criminal intent up to the age of 18 years. The three principles of criminal jurisprudence in India are: 1. The onus lies affirmatively on the prosecution to prove its case beyond reasonable doubt, and it cannot derive any benefit from weaknesses or falsity of the defense version while proving its case. 2. That in a criminal trial, the accused must be presumed to be innocent unless he is proved to be guilty. 3rd, that the onus of the prosecution shifts. Juvenile justice system is an offshoot of the criminal jurisprudence and so the same principle holds true even in the juvenile justice system. Any child shall be presumed to be an innocent of any malefied or criminal intent up to the age of 18 years. The Article 11 of the Universal Declaration of the Human Rights UDHR states, everyone charged with a penal offence has the right to be presumed innocent until proved guilty according to law in a public trial at which he has had all the guarantees necessary for his defence. While this principle stands in the court of law, the criticism stems from the terminologies used in the Act, which creates a sense of confusion. In the criminal justice system, an adult who is alleged to have committed an offence is called an accused, while in the JJ Act makes no distinction in the terminology used for a juvenile who is alleged to have committed an offence and the child who has been found to have committed the offence. They both are called children in conflict with law. The only difference that demarcates them is the word alleged. Now we come to the second principle, where we are talking of the principle of dignity and worth. All human beings shall be treated with equal dignity and rights. This principle reflects Article 1 of UDHR, which stipulates that all human beings are born free and equal in dignity and rights. This inherent right to dignity and worth, to which the preamble of CRC makes explicit reference, has to be respected and protected throughout the entire process of dealing with a child in the JJ system. In India, the Supreme Court ruling in the case of Francis Correll versus Union Territory of Delhi gave a new dimension to Article 21 of the Indian Constitution, which stated that no person shall be deprived of his right or personal liberty except according to a procedure established by law. The ruling held that the rights to live includes the right to live with human dignity and all that goes along with it. For example, the bare necessities of life such as adequate nutrition, clothing and shelter over the head and facilities for reading, writing and expressing oneself in diverse forms, freely moving about and mixing and mingling with fellow human beings, and must include the right to basic necessities, of life, and also the right to carry on functions and activities as constitute the bare minimum expression of human life. The third principle is the principle of participation. This specifically in the context of children is very important. Every child shall have a right to be heard and to participate in all processes and decisions affecting his interest, and the child's view shall be taken into consideration with due regard to the age and maturity of the child. This is what is mentioned in the Juvenile Justice Act. Article 12 of UNCRC states, children shall be assured the right to express their views freely in all manners affecting them, their views being given due weight in accordance with the child's age and level of maturity. Thus, the principles of participation encourages adults to take children in confidence while taking and making decisions for them. Each child has a right to be heard and to present his opinion in all processes and decisions which are related to him or her. Children can't be just seen beneficiaries of services, but have to be seen as partners in the process. The next principle is the principle of best interest. The JJ Act states that all decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child and to help the child to develop full potential. Article 3 of the UNCRC also states that the best interest of the child shall be a primary consideration in all actions affecting children. The term best interest broadly describes the well-being of a child. Such well-being is determined by a variety of individual circumstances such as the age, the level of maturity of the child, the presence or absence of the parents, the child's environment and experiences. Since it is the adults who make decisions on behalf of the children, the above conditions must be kept in mind during decision making. The next principle is the principle of family responsibility. The primary responsibility of care, nurture and protection of the child shall be that of the biological family or adoptive or foster parents, as the case may be. The family is considered to be the natural and primary caregiver who is obligated to safeguard and protect their children. All decision making for the child should involve the family unless it is not in the best interest of the child to do so. The family includes the biological family, the adoptive or foster care family in that order. It must be held responsible and provide necessary care, support and protection to the child under the care and custody under the Act, unless the best interest measures or mandates dictates otherwise. This has been recognized by the preamble of UNCRC, which reaffirms the fact that children, because of their vulnerability, need special care and protection, and it places special emphasis on the primary caring and protective responsibility of the family. Besides this, Article 5, 9, 10 and 21 have all reiterated the importance and role of family mentioned below. Article 5, which is about parental guidance and the child's involving capacities. The state must respect the rights and responsibilities of parents and the extended family to provide guidance for the child that is appropriate to his or her evolving capacities. Article 8 speaks about preservation of identity. The state has an obligation to protect and, if necessary, re-establish basic aspects of the child's identity. This includes name, nationality and family ties. It must be remembered that many of these children who come in the system, in the juvenile justice system, as children in need of care and protection, may or may not have families. So, the identity of the child becomes a big question. Article 10 speaks about family reunification. Children and their parents have the right to leave any country and to enter their own for purposes of reunion or the maintenance of the child-parent relationship. Article 21 talks about adoption. In countries where adoption is recognized and or allowed, it shall be carried out only in the best interest of the child and then only with the authorization of competent authorities and safeguards for the child. The next principle is the principle of safety. All measures shall be taken to ensure that the child is safe and is not subjected to any harm, abuse or maltreatment while in contact with the care and protection system and thereafter. It also presumes that at all stages from the initial contact till such time he remains in contact with the care and protection system and thereafter, the juvenile or the child in conflict with law shall not be subjected to any harm, abuse, neglect, maltreatment, corporal punishment or solitary or otherwise any confinement in jails, and extreme care shall be taken to avoid any harm to the sensitivity of the juvenile or child. Article 24 of the Indian Constitution prohibits children below the age of 14 years from being employed in any work in any factory or mine or engaged in any other hazardous employment. UNCRC articles 32, 33, 34, 35, 36 and 37 also state provisions for protection of children from work that is dangerous or might harm their health, deny access to education, expose them to sexual exploitation and abuse, abduction, sale, trafficking, etc. There are also provisions mentioned to safeguard children under corporal punishment, which have been incorporated in the JJ Act of 2015. We talk about the next principle of positive measures. All resources are to be mobilized, including those of family and community, for promoting the well-being, facilitating development of identity and providing an inclusive and enabling environment to reduce vulnerabilities of children and the need for intervention under this Act. This principle has been taken from the United Nations Standard Minimum Rules for the Administration of Juvenile Justice 1985, better known as the Beijing Rules. Article 1 under the Beijing Rules 1.3, which states that sufficient attention shall be given to positive measures that involve the full mobilization of all possible resources, including the family volunteers and other community groups, as well as schools and other community institutions, for the purpose of promoting the well-being of the juvenile with a view to reducing the need for intervention under the law and of effectively, fairly and humanly dealing with the juvenile in conflict with law. This also includes developing measures for dealing with children in conflict with law without resorting to any or resorting to minimal judicial proceedings by strengthening or community based programs such as community service supervision and guidance by, for example, social workers or probation officers, family conferencing and other forms of restorative justice, including restitution, compensation of victims. The ultimate aim is to reduce the vulnerability of children and the need for intervention. Now we speak about the next principle, which is the principle of non-stigmatizing semantics. Principle of non-stigmatizing semantics. Adversarial or accusatory words are not to be used in the processes containing to a child. The Delhi Juvenile Justice Care and Protection of Children Rules 2009 had elaborated on this point to state that the non-stigmatizing semantics of the Act must be strictly adhered to, and the use of adversarial or accusatory words such as arrest, remand, accused, charge sheet, trial, prosecution, warrant, summons, conviction, inmate, delinquent, neglected, custody or child or jail is prohibited in the process pertaining to the child or child in conflict with law under the Act. This principle helps to protect rights of the children and they should not stigmatizing during the process. It also provides protection to them from using adversarial or accusatory words. Now we talk of the next principle, which is the principle of non-waiver of rights. As per this principle, no waiver of any of the rights of the child is permissible or valid whether sought by the child or person acting on behalf of the child or a board and committee, and any non-exercise of a fundamental right shall not amount to waiver. The Delhi Juvenile Justice Care and Protection of Children Rules 2009 also had stated that the non-exercise of fundamental right does not amount to waiver. Brings us to the next principle, which is the principle of equality and non-discrimination. The Act says that there shall be no discrimination against a child on any grounds including sex, caste, ethnicity, place of birth, disability and equality of access, opportunity and treatment shall be provided to every child. This principle is derived from Article 15 of the Constitution of India, which states that the child shall not discriminate against any citizens on the grounds only of religion, race, caste, sex and place of birth or any of them. Also, Article 2 of the UNCRC states that the convention applies to all children, whether whatever their race, religion or abilities, whatever they think or say, whatever type of family they come from. It does not matter where children live, what language they speak, what their parents do, whether they are boys or girls, what their culture is, whether they have a disability or whether they are rich or poor. No child shall be treated unfairly on any basis. The next principle is the principle of right to privacy and confidentiality. Every child shall have a right to protection of his privacy and confidentiality by all means and throughout the judicial process. Article 16 of the UNCRC speaks about how children have a right to privacy. It states that the law should protect them from attacks against their way of life, their good name, their families and their homes. Similarly, Article 8 of the Beijing Rules stated that the juvenile has the right of privacy and no information should be published which helps to disclose the identity of the child. The next principle is the principle of institutionalization as a measure of last resort. A child shall be placed in an institutional care as a step of last resort after making a reasonable inquiry is what the Act states. As per Article 9 of the UNCRC, children have the right to live with their parent unless it is bad for them. Children whose parents do not live together have the right to stay in contact with both parents unless this might hurt the child. Foster care has to be seen as the next option. Those without parents, there is a need to explore adoption as a means of rehabilitation. Finally, if none of these measures are an option or in the best interest of the child, then and then only shall the option of institutionalization be explored as a matter of last resort. The next principle is the principle of repatriation and restoration. Every child in the JJ system shall have the right to be reunited with his family at the earliest and to be restored to the same socio-economic and cultural status that he was in before coming under the purview of this Act, unless such restoration and repatriation is not in the best interest. Repatriation involves all actions taken after the rescue of the children till their effective restoration within their families or legal guardians or others in the proceedings outlined under the JJ Act and the rules laid down in this regard. Repatriation shall include interstate repatriation. If the child belongs to the state of rescue and they are interstate repatriation, if the child is from another state in the country, and repatriation shall be cross-border as well. The term rehabilitation and social integration shall include the processes included in Chapter 4 of the JJ Act. The term rehabilitation shall include the economic rehabilitation of the family and educational rehabilitation of the child. Next is the principle of fresh start. All past records of any child under the JJ system should be erased except in special circumstances. This principle is related about fresh start. It means it gives a chance for children to start a new life. This principle expects all past records to be erased except in special circumstances. While children who have offended must be held accountable for their actions, every child has the capacity to change for the better and must have a second chance. This is the right to a fresh start. At the same time, all the children who have experienced abuse and exploitation too deserve a fresh start so that they can move on in their life. Hence, publication of the photographs of the children have been prohibited unless due permission have been taken from officials who feel that publishing photos may be in the best interest of the child. For example, publishing the photo of a missing child. The next principle is the principle of diversion. It measures of dealing with children in conflict with law without resorting to judicial proceedings, and it shall be promoted unless it is in the best interest of the child or the society as the whole. Diversion has been identified as a positive and cost-effective contribution towards the rehabilitation and reduction of reoffending of child offenders. Depending upon the severity of the offence committed, the law mandates that the system to explore options where judicial proceedings may not be used. In this context, the model JJ rules has provided for non-filing of FIR for petty offences. Section 83G of the JJ Act 2015 provides for transferring to the committee, that is the Child Welfare Committee, all matters concerning the child who is alleged to be in conflict with law. It is stated that children in conflict with law need to be treated as children in need of care and protection at any stage, thereby recognizing that a child in conflict with law can also be a child in need of care and protection. In other words, a child in conflict with law can also be treated as a child in need of care and protection simultaneously, and there is a need for the committee and the board to both get involved while working with these children. The aim is to divert children into diversion programs where they can learn life or vocational skills and thereby integrated into the community. Diversion can happen at any stage of the juvenile justice process. This principle seeks to establish a formal framework for dealing with children in conflict with law throughout the criminal justice process, with a view to ensuring that detention or institutionalization is a measure of last resort. Now we are going to talk about the principles of natural justice. Basic procedural standards of fairness shall be adhered to, including the right to a fair hearing, rule against bias, and the right to review by all persons or bodies acting in a judicial capacity under this Act. Which brings us to the next principle of the principle of natural justice. This is about procedural fairness and ensures that a fair decision is reached by an objective decision maker. Maintaining procedural fairness protects the rights of the individual and enhances public confidence in the process. Principles of natural justice are firmly grounded in Articles 12 and 21 of the Constitution. The two basic principles of natural justice are nemo juris in causa sua. No one shall be made a judge in his own cause, or rule against bias, that is, hear the other person, or no one should be condemned unheard, or rule of fair hearing. Summarizing, the principles of the juvenile justice system is no different from those defined in the Charter of Human Rights and applicable to the adult criminal justice system. In this module, we have seen the 16 principles enshrined in the Juvenile Justice Act of 2015. We have also looked into the context from where these principles have been derived and its significance within the JJ system. These principles have been primarily taken from the Indian Constitution, UNCRC, UDHR and Beijing rules. All these 16 principles are clearly given guidelines laid down for the purpose of enhancing the working of all stakeholders while dealing with children, as it helps build perspectives in the context of which the spirit of the Act has to be understood. For additional reading, you are requested to kindly look at the references that have been given in this module. There is also a lot of content that is available online. Thank you.